our live session here at Synapse Global Institute. I am delighted to have you join us for today's lecture on Chapter 10, which explores the foundational concepts of partnership within the context of law and governance. As we embark on this topic, I encourage you to engage actively, ask questions, and connect the concepts to real-world scenarios, particularly those relevant to the Kenyan legal framework and international comparisons. Let us begin by understanding what a partnership is. A partnership, at its core, is a business arrangement where two or more individuals or entities come together with the intention of carrying on a business for profit. This simple definition carries significant legal implications and shapes how businesses are formed, managed, and dissolved. In Kenya, partnerships are primarily governed by statutory laws, notably the Partnership Act of 2012, alongside common law principles and the unique terms crafted within each partnership agreement. The statutory definition, as laid out in the Kenyan Partnership Act, 2012, succinctly describes a partnership as the relation which subsists between persons carrying on a business in common with a view to profit. This definition is mirrored in other jurisdictions, such as the United Kingdom's Partnership Act of 1890, highlighting the universal nature of the partnership concept. The emphasis here is on the relationship between persons, the collaborative nature of the business, and the underlying profit motive. When we dissect the key elements of a partnership, several features emerge as essential. First, there must be an association of persons, meaning at least two individuals or entities must unite for a partnership to exist. This is not merely a gathering, it is an intentional coming together for a common business purpose. Second, the group must be carrying on a business, whether that involves trading goods, providing services, or engaging in any commercial activity. Third, there is a clear common purpose, with all partners working towards shared goals. Finally, the profit motive is central. The primary aim of forming a partnership is to generate profit, distinguishing it from non-profit or charitable organizations. Understanding these foundational elements sets the stage for exploring the characteristics that define partnerships. Partnerships are unique in their formation, management, and legal responsibilities. One of the most critical characteristics is the agreement between partners. This agreement can take various forms, written, oral, or even implied by conduct. For instance, a group of individuals pooling resources to run a retail store, even without a formal written agreement, may be deemed partners if their actions demonstrate a mutual understanding and shared business objectives. Sharing of profits and losses is another defining trait. Partners agree on how profits and losses will be distributed, often documented in the partnership agreement. If two partners contribute equally to a business, they may choose to share profits and losses on an equal basis. This arrangement not only incentivizes collaboration but also ensures that risks and rewards are distributed fairly. Joint management is integral to the partnership structure. Unless otherwise specified, all partners have the right to participate in the management and decision-making processes of the business. Take, for example, a law firm partnership. Each partner may contribute to strategic decisions, operational management, and client relations. This participatory approach fosters a sense of ownership and accountability among partners. A particularly important concept within partnership law is mutual agency. Each partner acts as an agent of the partnership, meaning that their actions within the scope of the business can bind the other partners. This principle was established in the landmark case of Cox versus Hickman, 1860, where the court held that mutual agency is a key characteristic of partnerships. The implications of mutual agency are profound. If one partner enters into a contract on behalf of the partnership, all partners may be held liable for its fulfillment. Unlimited liability is a concept that often distinguishes partnerships from other business forms. In general partnerships, partners are personally liable for the debts and obligations of the partnership. If the partnership cannot pay its debts, creditors may pursue individual partners for payment, potentially impacting their personal assets. This risk underscores the importance of trust and due diligence when selecting partners. The legal identity of a partnership is another area worth noting. Traditionally, a partnership is not considered a separate legal entity from its partners. The business and the partners are legally the same, meaning that legal actions against the partnership are effectively actions against the individual partners. However, there is an exception in the case of limited liability partnerships, LLPs, which are treated as separate legal entities. This distinction has significant implications for liability, taxation, and continuity. Partnerships are formed voluntarily, reflecting the free will of individuals or entities to collaborate for mutual benefit. This voluntary nature is foundational to the partnership model and contributes to its flexibility and adaptability across various industries and sectors. Central to the partnership relationship is trust and confidence. Partners owe each other fiduciary duties, including loyalty, good faith, and fair dealing. These duties ensure that partners act in the best interests of the partnership and refrain from self-dealing or actions that could harm the business or other partners. Having established the nature and characteristics of partnerships, let us turn our attention to the various types of partnerships recognized under Kenyan law and international practice. The main types include general partnership, limited liability partnership, LLP, and partnership at will. A general partnership is the most common form, where all partners share unlimited liability and participate in the management of the business. This structure is straightforward and suitable for businesses where partners wish to be actively involved in day-to-day operations and decision-making. Limited partnerships introduce a distinction between general and limited partners. At least one partner assumes unlimited liability and manages the business, while others contribute capital and have limited liability, meaning their risk is restricted to the amount invested. Limited partners typically